Yes, Mr. Isaacs.
As the court pleases, Your Worship, I do confirm my appearance on behalf of the applicant in this matter, assisted by Mr. Kipido and Ms. Ipinge. We are always also ready to proceed.
You may proceed.
Thank you, Worship. If the court can just remind the witness they're still under oath.
Mr. Inambao, you are still under oath.
Thank you, Worship.
All right.
Good morning, Mr. Inambao.
Good morning.
I also again will try to put my questions as clear as I can. My learned colleague referred to the assets as 9 service stations. Is it correct that what was bought was the right, title and interest in these assets in terms of the asset purchase agreement?
Your Worship, the asset register that was provided by NAMCOR through the accounting firm, Your Worship, listed those assets which NAMCOR was acquiring. And they had names: tanks, canopies, pumps, and so forth and so on, Your Worship.
So, I'm really trying. Are you saying that I'm wrong, that what was not bought was not right, title and interest in these assets? Are you saying I'm wrong?
Your Worship, when somebody buys an asset, it means eventually they will have the rights and titles to those assets because they bought them.
All right, so you confirm that the subject matter was the right title, right title and interest in these assets.
Your Worship, I said it was assets.
It was right, title and?
Right title and interest.
And the answer is?
Assets, Your Worship. And hence I was referring to the list that was attached to the contract, the asset register, which provided the list of the assets. The evaluation report conducted by NAMCOR, it also provided and listed those assets. So the fact that they were buying assets, it meant that they would have the rights to use those assets.
I don't know whether that is, I'll take the answer as it is. I'm sure we'll not end at 1 o'clock at this rate. Mr. Inambao, can you dispute that at the time of the asset purchase agreement, that Mr. Willemse was informed by the Executive Sales and Finance Administration Executive, yes, that the budget was approved for these assets?
I cannot dispute that, Your Worship, but we have seen an instruction which was sent by Mr. Willemse to Ms. Olivia, where he indicated that there was budget provided for.
But Mr. Inambao, I did not ask about Ms. Olivia. Can we really try to answer my questions?
I have answered the question.
Can I refer you to page 253, capital A of bundle 2?
You said which page again?
253, capital A.
I'm there.
You'll see, sorry, Your Worship.
You may proceed.
Thank you, Worship. Can you go to the last paragraph? It says purchase and sale of assets. Are you there?
I'm there.
Please read that into the record.
Purchase and sale. On and subject to the terms and conditions of this agreement, NAMCOR Trading agrees to purchase from Enacon, and Enacon agrees to sell and transfer to NAMCOR Trading all of Enacon's rights, title, and interests in and to the assets. The asset register signed by Enacon's auditors set out under proceeding, that is to the next page, Your Worship, Exhibit B, before the effective date. Enacon shall deliver to NAMCOR Trading all certificates, ownership documents, registration documents, asset maintenance records, asset register as signed by the auditors, warranties, if any, or any other documentation is necessary to ensure transfer of ownership of the assets to NAMCOR Trading.
Thank you, sir. I want to take you back to the emails that is before court as F1. But before I do that, may I just ask, is it your testimony that Mr. Willemse in those emails stated that the acquisition was approved, the acquisition of the assets was approved by the board, or that the budget was approved by the board? Which of the two was it?
Your Worship, we can look for that email so we can read how the context of that email is.
I'm asked what your testimony was.
My testimony, I said there were the directives that were given by Mr. Willemse to Ms. Olivia as to how to compile the internal memorandum,
All right.
in which he indicated, among others, that budget was provided for.
Okay. Mr. Inambao, are you aware that the police, before the accused person's arrest, visited the farm of Mr. Willemse to confirm that he had animals on the farm? So the question is, are you aware of that visit?
I'm not aware of the visit
Thank you.
by the police.
Thank you. It is evidence of Mr. Willemse that during his arrest, one of the police officers asked him, where is the whereabouts of his 287 cattle? Do you know anything about this?
It's specific. It was a police officer who asked him. I'm not aware of that. What I know is when he was arrested, he was informed of the charges, his legal rights and constitutional rights, and he elected to remain silent. So, as to whether that question was asked to him, I have no idea.
Thank you for adding the other part. I see during your testimony, when you testified about the Heard statement, you said that is unfortunately on the Heard statement you cannot see how many cattle were slaughtered, correct?
That's correct.
Does Heard statements indicate slaughtered animals?
Your Worship, I believe I read the categories that are prescribed on that form, on the head statement, the day that I was, it was provided to me by, before the court. And I believe the categories which are there, it's the date of registration, the tag number, the breed, the type of livestock, and so forth and so on. There's no category indicating as to whether that stock has been alienated or sold or slaughtered.
Yes. Mr. Inambao, do you agree that a person can commit corruption for the gratification of another person?
Most definitely.
In other words, for the complete crime, you don't need the person who commit the corruption to receive the gratification.
That's correct.
For example, if someone corruptly or commit corruption in terms of the asset purchase agreement and Enercon received 53 million, that would be the gratification for Enercon.
That's correct.
But the crime will be completed whether or not whoever acted to create that gratification, it's not necessarily that that person must receive gratification, correct?
You were saying for an example. So in the example that you are, when you are saying an example, 53 million being the gratification,
Yes.
Yes, but not where there was a conspiracy. Because if there was a conspiracy, it means the people planned and they conspired to commit the offense together. So, and the gratification in this regard can go either ways.
Is that your answer?
That's my answer.
All right. It follows that whoever signed that internal memo that we referred to in this court, and there was a misrepresentation or there was corruptly confirming the acquisition, all of them are guilty whether or not they receive a gratification. Correct?
I don't agree with you, because it's only the court which can pronounce itself as to whether the person is guilty or innocent after the evidence has been presented before the court.
All right.
So as to whether there are suspects, investigations is ongoing, and evidence is the one which determines which direction we are going to take or have taken.
Yes, but the evidence, when did you obtain a copy of that internal memo?
I believe the internal memo was part of the annexures of the complainant statement when the case was reported. So that was, I believe, in April. So we received that docket in June 2024.
All right. So since June 2024, you already had the memo, and then the suspects a year and where are we now? April, June, July, August, September, October, 3 months, 7 months. We're still looking for suspects. Is that what you're saying?
I said investigations is still ongoing.
Another example where a person can act corruptly and another person can receive that benefit would be to approve credit according to you above the credit limit. Would that be correct?
It's twofold. So I'm not going to say it's correct or not. I'll say it's twofold in a sense that when a business decision is made to increase the credit limit of an individual based on the decision that the business is making, I don't see a problem with it.
I see.
But where there is a conspiracy, where there's collusion, where the staff members, the very staff members that are the ones approving the credit, then it becomes corruption, because they ended up receiving gratification for having approved the credit limit. I mean, the supply of fuel above the credit limit.
Yes, but also even if you don't receive gratification, you're also guilty of corruption. Correct? Even if you don't receive for yourself, but the gratification is now the fuel. It's not so.
Not necessarily.
Mr. Inambao, I want to deal with the credit policy now, which can be found on page 147 to 158 of Bundle 1.
Page 100 and?
47, Your Worship. Bundle 1.
I'm there.
Thank you. Now, Mr. Inambao, can you deny that Mr. Willemse only became a member of the credit committee on 1 July 2022?
Is it 1 July or 1 June?
1 July 2022.
I know he became a member of the credit committee when he was appointed in a permanent capacity, which was, I believe, June, July 2022.
So the answer is maybe or maybe not, or what?
We do have, I believe, his appointment letter here to confirm the date, and I want to believe that the date that Mr. Willemse signed is 1 June, if I'm not mistaken.
Yes.
Yes.
But 1 June he was also co-acting. Did immediately become a member of the credit committee. Do you know that information?
Well, whether he became a credit committee member after 1 June, it doesn't really make a difference because the purchase orders which he approved, they are after June.
Mr. Inambao, did I ask you about the purchase orders?
I
I
believe
just want to establish one fact before you.
I believe I've answered your question.
Okay. Can you deny that at the time, that is now 1 July 2022, when Mr. Willemse became part of the credit committee, that both Enercon and Irongo was already boarded as clients of NAMCOR?
Correct. They're already customers.
When a client is boarded, who sets the limit, the credit limit?
I believe that consideration is done by the credit committee and is approved by the managing director, also depending on how much that customer's limit or rather application was.
Yes, it's common cost that over 500,000, the MD must approve.
That's correct.
Okay. Can you dispute that at the time that both Enercon and Irongo was that the time that Mr. Willemse became part of the committee, that Enercon and Irongo was already categorized?
I believe that was the case because they were
Just a
already
moment.
customers.
What is the question? I didn't get
At
the
the time,
question.
sorry, may I
You
proceed?
may just repeat the question.
Repeat the question, yes, thank you. At the time Mr. Willemse became part of the credit committee, both Enercon and Irongo was already categorized in terms of the credit policy.
Yes, they were.
According to your investigation, in which category did Enercon fall?
Your Worship, during the investigation, the question of categories was not explored, but I did testify before this court that when Irongo was onboarded in 2021, if I'm not mistaken, Your Worship, they were given a credit limit of 3 million. And that was reviewed in 2020, they were onboarded 2020, and that was reviewed in November 2021 when their limit was adjusted to 10 million. And we know, of course, Enercon was onboarded on 16 March, and they were provided, rather granted a credit limit of 15.5 million.
Are you done?
I'm done.
All right. So you don't know. Second question, or next question. According to your investigation, in which category did Irongo fall?
I answered that one.
No, I asked you about Enercon.
I believe I answered for both.
Or you anticipate questions?
Of course.
Okay. So, it is your evidence then that in November 2021, when the limit was raised, is so that Mr. Willemse was not yet part of the credit committee. Correct?
That's correct.
the limits that you are referring to, i.e. 10 million and 15.5 million for Irongo and Enercon respectively, my instructions are that these are monthly limits. Meaning that limit is that what you can take in a month.
Your Worship, whether they are monthly or annual limit, the matter remains that they were given these limits. And if they exceeded those limits, then credit committee would need to come in. So they were given limits, and those limits were set.
Mr. Indambao, can you dispute the limits was monthly?
The contract is here.
Can you dispute it?
I'm saying they were given limits. I cannot dispute it.
Thank you, sir. You testified that on 29 November 2021, the guarantee was cancelled. The guarantee of Enercon, in fact, was cancelled. You agree with me that Mr. Willemse was not yet part of the committee when it was cancelled?
Yes.
You also agree with me, Mr. Indambao, that when considering increment of any credit limit, that there are very factors that the committee must take into consideration.
That's correct.
And these factors are actually in the credit policy.
That's correct.
You also agree with me that credit limits are not set in stone. It depends on the customer.
I believe the credit limits are set in stones. That is why when a customer signs an agreement, the terms and conditions, they specify the limits which the customer, or rather in this regards, the customer and the managing director signs. But then the customer can still come back to NAMCOR and request, and hence the existence of the credit limit, because it's provided for.
Yes.
Customers can be allowed, provided this and that is met.
Yes. So customers are allowed for increase. On 1 July 2022, when Mr. Willemse joined the credit committee, what was the credit limit of Enercon?
The credit limit of Enercon has always been 15.5 million, and it has never changed.
I'm just asking a question.
I
Can you just
have
answer the
answered.
question? Say 15.5 is the answer.
And I need to make sure that you also understand that the limit has never changed.
The court can just bear with me, please. You testified that at one point, or before I come to that, who waived Enercon's guarantee?
I testified and indicated that Ms. Hamukwaya indicated there was something wrong with the guarantee, and therefore it was cancelled.
Yes. This guarantee waiver was before Mr. Willemse became part of the credit committee, correct?
That's correct.
You testified as it stands, Energon owes in terms of credit 35 million, give or take a few thousands, correct?
Yes, that's correct.
How was it raised from 50.5 to 35? When, and let me ask you, when did it go from 50.5 to 35 million? Was it a once-off or was it gradually?
Can I ask you maybe just to step back a little bit?
I will.
To the question before that one, just to make sure that, when I answer, there's a bit of consistency.
You mean the guarantee?
Yes. No. The fuel of Enacon.
Yes.
The question just before the one you were asking now.
I said, as it stands, Enercon owes NAMCOR around about 15 million, excluding the session debt.
Yes.
Now, the credit limit, according to you, was never raised or never authorized. So from 50.5 million to 35 million, was it raised gradually or was it raised once off?
Your Worship, as I indicated, the limit always has been 15.5 million. This is the reason why we are here. It's because Enacon NAMCOR continued to supply fuel to Enacon despite having exceeded the limit of 15.5 million. So meaning there were several transactions which went beyond the credit limit. So, and that is the one which brought the problem. It's not because the credit limit was increased, it's because the staff members authorized the supply of fuel above the credit limit. From 15.5 million to 35 million.
I'm still trying to find the answer in this lecture that you give. Please answer my question. The 50.5 million to 35 million, the unauthorized credit, was it gradually or was it once off?
No, it was gradual.
Gradual.
Yes, but I want to be specific and I want to make sure that you don't misunderstand me.
Okay.
Because it was not an increase of the credit limit.
Yes. I do understand.
The credit limit remains 15.5. So, meaning Enacon would send purchase orders and the credit, or rather, staff members of NAMCOR will continue supplying fuel despite this limit that was set.
Yes. I hear you.
Thank you.
Now, at some point, you call it zero-rized. When the asset purchase agreement was concluded and the money was paid over to Enercon, they paid 35 towards the debt, correct?
That's correct.
5 million. All right. And then between, I think, you say May to, is it August, or May to December, it again went up to 35 million.
That is from August 2022 to December 2022.
To December 2022. All right. How much of that authorization did Mr. Willemse, was he involved to get to 35 million?
Your Worship, I don't remember if there's a charge for Mr. Willemse relating to him having authorized fuel, the supply of fuel to Enacon during that period.
Oh, I see.
And I've never testified to that effect.
Oh, I see.
Otherwise, we would have disclosed those purchase orders.
All right. So the unauthorized fuel was only in respect of Irongo.
That's correct.
Okay. It is indeed your testimony that, according to Mr. Willemse, the credit committee will sit, deliberate on what is before them, and then they will authorize, or rather review, this increment, but at the end of the day, before fuel is released, the MD must sign off. Did you also find that procedure at NAMCOR?
Not so, Your Worship. In fact, the way the procedure was explained is any two of the committee members, they were within the credit policy. It made provisions for two of the executives to be able to authorize. The managing director could authorize alone, but in the absence of the managing director, the other two executives could. And what? I believe it's in the policy.
Sorry?
I believe it's in the policy.
Could what? You stop there.
Authorize.
Okay. So, are you saying that according to your interpretation of the credit agreement policy, that the two executives, if it's above 500, can authorize fuel without the MD? Is that what your testimony is?
I think we need to get away from the credit limit and the authorization of supplying fuel above the credit limit. I think there are two different aspects that we are maybe putting together here. So the credit limit, and I want to make sure that I explain it, so maybe going forward that we understand one another. The credit limit is set when the customer is onboarded. So you have this customer's limit is set 15.5 million. Let's take an example of NAMCOR. Should NAMCOR now have exhausted, their limit, they have reached 15.5 million, then they will come back to NAMCOR and say, you know what, we know we have exceeded our limit, allow us to exceed with this much. So in terms of the credit decisions, in terms of the credit policy, the credit committee could make recommendations and two executives would authorize allowing the customer to exceed their limit.
Are you done, sir? Are you done?
I'm done.
Question. Can the two executives, without the approval of the MD, authorize fuel above credit limit?
That's correct.
Where will you find that? In the credit policy.
If Your Worship, you go to page 153.
15?
Of 153, I believe we were at page 147. So 153, which is still the same document, the credit policy. We look at the roles and responsibilities. Specifically, I'm looking at 5.9.
Okay.
The NAMCOR Executive Finance, Executive Downstream Supply and Logistic, and Managing Director will take all credit decisions relating to customers, including credit, limit determination, and allocation to individual operating units as recommended by the credit committee.
Yes.
So, Your Worship, and as far as our investigations is concerned, the managing director alone could make that decision. But in the absence of the managing director, the two listed executives could also make that.
That is your interpretation of that policy, correct?
That is not my interpretation. That is the process that was being followed.
Who told you that? That's the process.
We have interviewed, Your Worship, among others, all credit committee members who are not accused persons before this court.
Can you also read 5.7? Seems that you are very selective in picking things.
5.7, I'm not selective. I'm reading what you asked me to direct you, and I directed you to where I was reading. You must just ask me to read for you 5.7.
Please do.
Credit applications up to 500,000 reviewed by credit committee and recommended for approval by the Executive Finance and Administration and Executive Downstream and supply and Logistics.
So 5.7 says if it's under 500, the two executives can approve. Now read 5.8.
all credit applications above 500,000 should be reviewed by the credit committee and recommended for approval to the managing director.
Where does it say in the absence of the managing director, the two executives can approve?
I think, you know, the way this policy was explained, when they are talking about the applications, I believe this is when the initial application or when the customer is onboarded. But as far as the process that was being followed, when it comes to the supply of fuel to already existing customers, these decisions were being made by the executives, not necessarily by the managing director.
Not necessarily. What does
Yes,
that mean?
I'm saying it's only in cases where the managing director is not there that the executives are not there, that the managing director would make that decision.
But Mr. Inambao, that isn't here in the credit policy. What you're saying, in the absence of the two executives, the manager director
Yes,
will take a decision.
I've explained, we have read it.
Okay.
You would even see from the approvals in terms of the purchase orders that are before this court, you will not see an approval from Mr. Mulonga. Because that was the process that was being followed. Even if it's not documented here, that was the process.
So you are saying that things were done at NAMCOR that's not necessarily following the credit agreement, credit policy.
That's not what I'm saying.
That is exactly what you're saying.
No.
Okay. Mr. Willemse, during cross-examination, testified that when a customer comes on board, the sales and marketing department, in conjunction with finance, will review. The credit committee does not deal with these applications. Would that be a correct proposition?
Your Worship, we were not very much concerned as to, you know, who reviews the application when the suppliers are onboarded.
Yes.
We were provided with the contracts that were already entered into by these suppliers, indicating the dates, indicating the quantities of fuel they requested for, and the credit limit that was provided.
Or the simple answer would be, I didn't investigate, I don't have a comment. That could also be the answer. Exactly the same answer. Mr. Inambao, who blocks customers that exceeded their limit or can't pay or exceeded
I believe
limit?
it will be finance department.
Is Mr. Willemse part of the finance department or was?
Finance, in fact, if I can take it back to the moment when the fuel order or the purchase order is received. So before finance can go and block a customer, it means this customer would have submitted a request to NAMCOR, and this request is sent to the credit committee, and the credit committee takes a decision whether to approve or to disapprove, and this is what happened.
Mr. Inambao, was Mr. Willemse part of finance at NAMCOR Trading? Is
No.
the question.
No.
Thank you. During your testimony, you testified that the exposure, total exposure of Enercon to NAMCOR was 108 million. Would that be correct?
That's correct.
But you also testified before court that Mr. Willemse is not charged anything related to the supply of fuel to Enercon, correct?
That's correct.
This session agreement of the 73 million was also signed, I believe, 2nd March 2022. We can just quickly go to that. Page 107, bundle 2. Bundle 2.
You may proceed.
Thank you, Worship. Are you there, Mr. Inambao?
I see it starts from page 103. Do you want me to go directly to 107?
I would really like it if you go to page 107 that I mentioned.
Okay, I'm there.
That's the date when the agreement was signed.
Too much, 2022?
At that time, it's common cause that Mr. Willemse was not part of the credit committee or permanent employed by NAMCOR, correct?
That's correct.
Now, let's talk about Irongo that you said that is actually the charges Mr. Willemse faced in regard to the providing fuel above credit limit. What was the credit limit of Irongo as on 1 July 2022?
The credit limit of Erongo was 10 million from November 2021, and it remained as such throughout 2022-2023.
Or the short answer is 10 million. When was the credit increased? Not increased. When the credit was increased to 10 million, was Mr. Willemse part of the committee?
No.
I think we should go to the. I'm looking for that statement of NAMCOR, brother Irongo. Statement of account file. I think it's page 379. That is bundle 2. This sorry, Worship.
You may proceed.
Thank you. This document was disclosed to us after a request was made to provide the age analysis of both NAMCOR and Irongo, and then the state provided us with this document. You also testified about that, do you remember?
I testified about the figures. I know the state had asked me questions relating to it as well.
Okay. So, what was the exposure for NAMCOR regarding the supply of fuel above the credit limit?
Your Worship, as I testified for the last 2 days, the total exposure for Erongo was 238 million.
All right.
Which happened between December 2022 through to May 2023.
If you look at this statement, you'll see that at some point in 2021, Irongo had a credit with NAMCOR.
Which column are you referring to?
The third column, on your right. The one in bracket, if you look at the first one.
The second, which is the second one on the document I'm having.
Sorry, sir? Are you there on page 379?
Yes, I'm there.
Right, there's 1, 2, 3, 4, 5 columns. I'm looking at the furthest right.
Furthest right, which date? March 2021.
Let's first establish what is credit and debit. The ones in the amount appearing in brackets, would that be a negative or a positive?
I believe you have indicated if it's in bracket. In terms of accounting language, if it's in bracket, it means it's a minus.
Okay.
But in this regards, it will mean that it was a credit, meaning a wrongo would have had credit if it's in bracket.
Yes. So on November 20, there was Irongo had a credit, as well as March 21, as well as June 21, as well as November 21. Those are all the months which shows credit. Correct?
That's correct. And this could be the reason as to why it was justifiable for NAMCOR to increase their limit. Because remember, that time it was still 3 million. That used to be their credit limit.
In November 2021.
I'm saying before November, because they only got their limit increased from November. So this was a justification as to why NAMCOR, increased the limit, because in terms of the conduct was good. They were paying even upfront.
Yes, and they also made payments from June 2022 to May 2023. There's also payments.
Yes, although there are payments, this time we must note that they are not having a credit balance anymore.
They didn't have a credit balance. Meaning what? But they have credit, most. It's not so.
No. I'm just going back to your previous question.
Okay.
The numbers in bracket. If we look at the numbers in bracket, so meaning their account was they were no longer paying, they were not paying in advance. Like they didn't have more money above their credit limit.
Oh, okay. So Mr. Willemse is in court because there was a credit limit and he authorized fuel above the credit limit. Correct?
We should not look at it in isolation from other factors. We are saying this is just one of the factors.
Yeah, but I hear you. But it's still one of the factors. Is in court. You keep on saying in this court, the reason why Mr. Willemse is here because he gave fuel above the credit limit. That's your song that you've been singing the whole 2 days. What other factors must we take into consideration?
When you just put it generic like that, you make it to look like a normal business transaction. Perhaps it's better you add the word corruptly authorized fuel supply to these entities. Then from there we can, yes. He
corruptly authorized fuel above the credit limit.
That's right.
Okay. Now, until November 2021, you said the credit limit was 3 million. For NAMCOR.
That's what our evidence established.
All right. So in November 20, fuel was provided above the credit limit. 2020.
I'm still trying to understand. You are saying November 2020?
If the credit limit was 3 million, fuel that was authorized by the then credit committee was 5 million.
And I just want to make sure that I answer you accordingly here. You said November 2020, which is the second column from the top.
Yes.
Where the account indicates a credit balance of 2.8 million, right? That is what you are talking about.
Yes, I'm talking about that line, but I'm not talking about the balance.
Okay, no. What I'm trying to say here is, you can already see that they were having a credit balance at the end of that column. So if you minus this from the 5, which it will bring you to almost 3.
I understand that. I just want to point out to you, looking at the numbers here, that fuel were provided for above a credit limit, meaning 5 million.
That is why they have a credit limit. It means they had made additional payments.
Do you agree? You see, because you said credit limit is cast in stone. The stone here that you are casting is 3 million. I'm showing you that stone was now turned to 5 million, the casting stone.
I think either you are not getting me here. What I'm trying to say is, it's in terms of these records here, they were supplied with fuel above 5 million, which is above the credit limit.
Okay.
But at this point in time, when you go on the far right, you would see that they had a credit balance, which could mean that they already had money in the account. I mean, they had already paid upfront.
Okay.
So meaning, if you have paid upfront, you can still exhaust your credit limit. You are still operating within your credit limit, and you leave some money aside.
You operate in terms of credit terms, not limit, because the limit is exceeded. Whether you had money or not, the fuel that was given was above the credit limit. So.
Not entirely correct. And you would remember when I testified about the cancellation of ENACON's credit guarantee. It means the customer can pay cash and they would still receive fuel. So if the demand at that point in time was higher, the customer has exceeded and NAMCOR has the stock.
Okay.
I'm sure it's a business transaction.
So let's look at April 2021. They took fuel, but now they owe 3.8 million above the credit limit.
And to me, that is normal. This is just 891 above the credit limit, meaning they could have gone to NAMCOR and actually requested for, to be supplied with fuel above their credit limit.
Okay, so there could be a request. There's a reason for the request, and then they will be given more fuel.
Yes.
Okay, we have that. Now, keeping that in mind, that it appears that fuel can be given above the credit limit, depending on what they're asking. Can we deal with Exhibit G now? Um, 113, I think is G1, Your Worship.
You may proceed.
So you testified yesterday that Mr. Willemse authorized fuel above the credit limit. And then you provide, or you testify about this document. Is it correct?
That's correct.
In this case, how much fuel did he authorize above the credit limit?
Your Worship, in terms of our investigations, the reconciliation is a little close to 26 million.
26 million.
That's correct.
And by this time, Irongo had a credit limit of 10.
That's correct.
Right. But if you look at the emails, it seems to me that specifically Mr. Willemse email, that was on Friday, 6 January 2023 at 4:38 p.m. He wrote to Olivia and he says, with reference to our discussion, I'm approving. Meaning there was a discussion. So it's not just something that was given to him and he approved. Do you agree?
And that is the approval which is being questioned. Because if you look also, there should have been other committee members that should have participated in that decision. But here you only see Mr. Willemse writing to Olivia.
Okay. Who is Mapenzi Festus?
Mapenzi Festus was the territory manager for the coastal region, I suppose. And he was the relations manager for Erongo specifically, meaning the fuel orders, they will go through him.
All right. So your problem with this one is that it was only the approval is only done between Mr. Willemse and Jennifer, or Dunaiski, or what? Is that the problem?
You see, when we say the approval alone, we must say the problem there is the corruptly approving. That's the problem.
Okay. What is the corrupt act here in the email?
Not necessarily in the email. The gratification was provided to Erongo in this regards because they operated above their credit limits. And we know that Mr. Willemse was receiving gratification from Erongos and the related entities.
Great. How much did you receive for this approval?
It's difficult for me to say how much he received for this.
When did you receive?
But we know that between 6 November and 18 December, he received at least over 1.1 million that was deposited in cash by Enercon's then acting chief executive officer.
Enercon.
Yes.
So Enercon
And I'm still
paid bribes in December for Mr. Willemse to approve in January.
And hence I'm saying it's the related entities. Because you would see as we listed the payments on the bank statement, all the entities are related. All these, in fact, Erongo and Enercon were operating at one office.
Mr. Inambao, is it your testimony that Erongo paid Mr. Willemse over 1.2 million to approve this order?
Not necessarily. I'm not really saying that this 1.1 was paid in respect of this purchase order.
No, what are you saying?
There was a corrupt relationship between Mr. Willemse, owners of Erongo, Enercon, and the related entities in which money was being advanced or paid to him during the course of the transactions which are in question.
Yeah, but Mr. Inambao, that money, according to your own testimony, was never paid in January. So are you telling me he was paid in advance for his corruption?
I mean, if this money was paid during December, these are cash deposits. And as I'm saying, investigations is ongoing. Evidence is there that he received money. So whether it was in advance, whether it was just a favor because they have been paying him, evidence is there.
Yes. So if it's a favor to pay someone, is it corruption?
He's still creating a gratification.
Is it corruption?
Yes.
Okay. Let's look at G3. Because I hear you complain that the other members were not there when decisions were taken. G3, your worship.
Page?
It was a exhibit that was said. It was one of those orders.
G3.
G3. I hope it is for 119. Purchase order 119. Do you have the document, Mr. Inambao?
I do.
You wish to the court with us?
You may proceed.
Thank you. Now, the first email that I see there is 6 April 2023 by Valerie Kanjavera. Are we together?
That's right.
Great. And that was sent to a lot of people, including Petrus Iniko, sorry if I pronounce it wrong, and Peter Shivambu. Who are they? Or who were they?
Yes, they are all employees. The ones you mentioned, they are all employees of NAMCOR and members of the credit committee.
Okay. What did they respond regarding this authorization?
They I did not see any response from them. In terms of the explanation that we obtained during the investigations, which is contained in their statements, Your Worship, is the decisions used to be taken without their involvement. Hence, there was no need for them to participate anymore.
Oh, they didn't write, listen, why you writing me the email? You're excluding me already. Nothing of that is in the email, correct?
Well, I cannot confirm that at this point.
But nothing of that is in the email. It's a very simple question. They did not say in the email, you have been excluding us, there's no need for us to participate. That is not in the email.
Yes, it's not in the email.
Yes. This email also shows that the approval is not in the air. There are discussions taking place. Of course, Mr. Willemse, according to this, says that based on this, I support the approval of the order. That is on page 4. Can you see that? It's VK9, there's a circle 4. I think it's the page just before.
No, I'm there.
Oh, okay. Did I read it correct?
Yes, based on this, I support the approval.
Yes, and if you look at the thread, as we call it, it seems to me there was a discussion about a condition for this approval, and that is the payment of 5 million to be paid by NAMCOR today. That is the email from Olivia Tunaiski on page 3. Payment of another 5 million to be paid 13 April. The remainder, as indicated in the request, on 26 April. A substantial amount will be paid towards the 60-day amount to be confirmed, and Phoenix confirmed that they are in the process of to evaluate customer asset guarantee approval will take 7 to 14 days still. So there's something is happening before the approval is granted.
Definitely in terms of this chain of emails, but what we are saying is, under normal circumstances, this is what was supposed to be happening. But there was a corrupt relationship which actually resulted in these approvals being made. I mean, we are talking about exceeding the credit limit from 10 million to 238, which defeats the purpose of actually having set the credit limit in the first place.
Yes, but you did. I'm not going to argue with that on that point. How much did Mr. Willemse get for this order?
I cannot confirm how much did he get for this order. As I was saying yesterday, this is organized crime. It's white-collar crime. So even if there's no money going into his accounts, we know there has been money over that period.
Over that period, let's be very precise with periods. You say over that period. Which period is that period?
That period we are talking about from August 2022 through to May 2023.
Okay. The payments that you said that you linked to this authorization is the payments of 1.2 million, correct?
And not only to this payment. I did say if we go back to the statement of Mr. Willemse and point out those payments, you would see the payments that he received even from Erongo and Oshali through that period. And what we are saying is there was a corrupt relationship which was happening. That relationship, those payments, they are the ones which actually made the staff members of NAMCOR to actually allow for this credit limit to be exceeded. I mean, this is not exceeding to 20 million.
Yes.
This is exceeding at least 238 million.
So the 150,000 in the 500,000 that they received in 2022, he authorized fuel in 2023. Is that what you say?
We are saying, even if there are no other payments that we can connect immediately when this was approved, there were payments that were being made by these entities to Mr. Willemse over the period of the investigations.
All right. So, in conclusion, you are saying that there's no direct evidence that those payments are for these purchase orders, but you infer that because of the corrupt relationship between Mr. Willemse and all other entities. Is
That's organized crimes.
Okay. That is your
And
evidence.
corruption. People try to hide, how they, to hide the transactions.
Mm. If I can just go to the last one, G2.
You may proceed.
Mr. Inamau, are you there?
I'm there.
I just want to make sure that I have it. It starts with Valerie Kanjavera on top.
That is G2.
G2, yeah.
It says
Yeah, for 117.
It starts off with from Jennifer Hamakwaya.
Yes, but the email is just on top of that. It's the name, not Valerie Kanjavera.
Oh, from Valerie Kanjavera.
Yes.
You may proceed.
Okay. Mr. Willemse informed me that this order was for Independence Day. That's why you see that, and that is his argument. Credit is not cast in stone. They're authorizing depending on an event or what's happening or the payment. In this case, it was approved because of a possible embarrassment to our government on Independence Day. Can you dispute that? For Independence celebration, sorry.
I was made aware during the investigations. You can see this was for jet fuel. So the army, or rather the Ministry of Defense, needed fuel in order to go and fly those planes at the independence celebration. But if you go to page 5, you would see that already by that time the account was already in excess with 198.
Yes, I'm with you. I'm happy that Mr. Willemse approved that. Otherwise, no jets would be flown on Independence Day.
But it also means that as much as we want to fly those jets, it doesn't mean that we must do things above the processes and procedures.
Would you agree with me that also I'm just going to see something. On page, I think page 1 to page 4. There's an email from Juliana Thursday, March 16. It says, "Dear Asnat, still awaiting from the MD's office. Will send through one received." What was that all about?
Which page is that one?
1, 2, 3. So it's the 4th page.
The 4th page from the top.
Yes, it's on the bottom. There's a Juliana, email from Juliana M. Caros Huas. I hope I don't.
Because my 4th page here is a purchase order from Erongo. Maybe they were in terms of sorting. What number do you have written with the pen there in the corner?
In the corner, there's
it's
no number.
VK7 something.
There's no number. Maybe the sergeant might also show the court to see if that page is in that bundle.
Let me just verify. 16 March 2023. Okay, let me find it. I think you can show it.
Okay, I have numbered it 21, page 21.
It's on page 21.
Yes.
Maybe Mr. Inambao, that is on your page 21 then.
Page 21.
I have numbered it G2, 21 of 22. because it's the last page is 22. That particular page is 21. I've numbered it.
It appears it's the
Oh,
second
yes,
last page.
Yes, second last.
Okay. You see that the subject is still referring to purchase order 117.
That's right.
And they're still waiting for the award from the MD's office. What is that?
Well, that's what the email is saying, but it looks like there were some engagements because it says, "Dear Julinda, it is with the acting MD as the trucks are waiting at engine and the fuel is for independence celebrations. Need to drive to Ondangwa and there are test flights planned. Engine
Yes.
is just waiting for NAMCOR."
Yeah, but it deals with the same purchase order, right? You discovered that to us yesterday. So here it seems to me there is indeed, and unlike you testified, we could find nothing from the MD. Here it is.
No. This is not an approval from the MD.
But the MD is involved in this. It's not so.
But you don't see the approval.
Okay.
So when somebody refers to the MD or to somebody else, if there is no evidence indicating that person is approved, there's no way I can say that person approved.
But they're still waiting for something from the MD to approve.
You can see this was on 16, and I'm just trying to go back. Despite having been waiting for the MD, maybe for some reasons the other executives was not there. That's why you see on that page where Mr. Williams approved, it was, in fact, this was, the approval was already done on the 15th.
A lot of maybes.
No, not maybe. It's
But you
here.
used the word maybe. I didn't use it.
I'm saying it's here on the email, 15 March.
But you said maybe the executives were not there.
No,
What is maybe?
I'm just assuming as to why.
Yes.
But in terms of the evidence, you don't see an approval from the MD or from the acting MD. The approval which is there is from Mr. Willemse.
Same question, Mr. Inambao. How much money did Mr. Willemse receive for approving with other members this particular purchase order?
Same as my previous answer. Because of the conspiracy, even if we are not able to point the money which he received on that day, it could have been received later.
Could have, yes. Lot of could haves. All right. You'd agree with me, there's no direct evidence that you can point to the court that Mr. Willemse received money from Irongo for this specific purchase orders.
You know, you earlier indicated that, a person can even receive, a person does not have to directly receive a gratification. Still an offense is committed.
Yes.
So, and that is the beauty about corruption, because it does not carry an ordinary meaning, but a technical meaning, in a sense that even if we are not able to prove here that Mr. Willemse received this money that day, a gratification was created.
But the beauty of testimony is also, you said that he did. You're not saying maybe, we cannot prove it. You said he received the money from Connie for these orders.
No, that's not what I said. I said investigations established he received money, and I was specific as far as the dates in terms of the transactions on the account, as far as the deposits are concerned. So we are saying those money that were received, it just goes to show the relationship, how. That this is the reason why, they were able to approve, it's a reason why they were not following the processes and procedures.
So maybe he got paid, or maybe he didn't get paid. Maybe he got paid.
Gratification was created.
Mr. Inamba. When these three decisions were taken, do you agree with me it was done in his official capacity? As a credit member?
Of course.
Okay. Now, let's go to the cash payments that you are referring to. You indicated during your evidence in chief that Mr. Connie van Wyk made cash payments of around 1.2 million, give or take, into Mr. Willem's account. Question, for what was it?
Your Worship, and I've been saying, since I started, these were bribes. In order for Mr. Willems and his colleagues to undertake activities like this.
Of those cash payments that Mr. Connie van Wyk made, how much did he receive? Where did he receive the money from?
Your Worship, and I was saying, simultaneously, if you go on the account of Erongo and NAMCOR and the other related entities, you would see cash withdrawals happening.
Again, it seems to me that you have an opinion about what happened. Inference that you want to draw. I'm very specific. I'm not saying look at the entities. He's here because of you. You are claiming he received payments from Erongo and the like. Is there evidence that you can point to this court where specifically Mr. Connie van Wyk got money from?
Your Worship, it's organized crimes. As I indicated yesterday, whatever the description that is stated on the bank there, it's descriptions which are there to disguise the true origin of those money.
Is it the cash payments that you said that was drawn from many entities and now being paid by Mr. Connie van Wyk? Was it for the asset purchase agreement? Was it for fuel that Mr. Willems authorized?
Your Worship, when it comes to the asset purchase, there are payments we were talking about yesterday. Those ones which were derived directly from the asset purchase. One of them is 1,040,000 Namibian dollars,
yes,
which went into his business account. The other one is 960, which went into his personal account. And we are talking about that other payment of 150, which was done on the 15th of July, Your Worship, from Erongo into Quality Meat Supplies, laundered via Quality Meat Supplies into Mr. Willem's account.
Is the 1.2 million gratification for the asset purchase agreement?
Your Worship, we believe that is in respect of the supply of fuel, authorizing.
Thank you.
Having authorized the fuel, supply of fuel above the credit limit.
Yes. Have you ever had an interview, or did you, since June 2024, was any of the accused persons ever interviewed to explain any transaction on any bank account or any business? Any of the accused in this case?
No, Your Worship, and the reason is there were suspects at the time. That opportunity was given when we arrested them.
Oh, I see.
Yes. So that at that point in time, they elected to remain silent. So why must we force the questions on them?
So what did you ask Mr. Willems on the when you said when we were arrested they were given the opportunity? Let's zoom into Mr. Willems. What did you ask him on arrest regarding all these charges?
What did I ask him?
Yes,
he was informed of the charges.
Yes.
He elected to remain silent. He had to exercise his constitutional right of remaining silent, despite the charges being explained to him, and therefore no questions were asked. You will see even in the poll 17 that when he was charged, he elected to remain silent. So therefore there was no questions that was asked to him.
So you didn't ask any question regarding where the money come from, why was he paid, why there was beef, meat? None of these questions were posed to him.
I believe I've answered you, Mr. Isaacs.
None of these questions were posed to him, is it correct?
There's an answer now that he elected to remain silent.
He said that there's the right to legal representation. I'm asking whether he asked the specific questions. He said he was informed about your rights. It was read. My question is, was he specifically asked? And did he say, I remain silent? That's my question, really.
I think you didn't understand my answer there. I said, when he was arrested and when he was charged, and I didn't use the word charged, I referred to the Pol 17. The charges were explained to him, and he exercised his constitutional right of remaining silent, and which is what we have done. It's within his constitutional rights, because he wanted to come and explain the situation to you.
Mr. Nambao, my instruction from Mr. Willems is that he was in fact denied his right to a lawyer because he wanted to contact a lawyer on the day of arrest, and you deny him that right.
Your Worship, that is unfounded and untruthful, because we had provided him the opportunity. Of course, we did not allow him to use his cell phone, because his cell phone, Your Worship, is the one he used to call the other people.
Again, thank you for that extra evidence. We'll be here the whole day, that I can promise you.
I'm here for you.
Now, you said you asked Mr. Connie van Wyk also, and he also elected to remain silent.
I never said I asked Mr. Connie van Wyk. I said Mr. Connie van Wyk is a suspect, is rather an accused person in the case.
But Mr. Nambao, my learned friend asked, did Connie explain the rental to you? He said, no, he opted to remain silent. That's what you said yesterday.
You said I asked. And I'm just trying to point that out, that I didn't ask him to explain. Because when we arrested him, he did the same like all the others, to remain silent.
Okay. Who arrested Mr. Willems?
I testified Mr. Willems was arrested by Mr. Becker, rather Commissioner Becker.
My learned friend put to Mr. Willems taking through every single cash deposit after July 2022. I asked us 10-6, then I think it's 7 or 8, or maybe 12. It took us half an hour to get through this, each and every one he asked. And then the prosecutor says that these are bribes. But what I did not hear my learned friend said to Mr. Willems is that all the other payments before that period were also bribes. But your testimony is that even before fuel was given, all this money in the account are bribes. Is it correct?
Your Worship, when I testified, there were specific transactions which were individualized on the account statement.
Okay.
I am not privy to the other questions and other transactions that the state has asked. I didn't testify unless I testified on them.
Let's go to each and every one, and then you can tell us where that money comes from.
And I must mention, Your Worship, that we are still busy with a comprehensive financial analysis. So I believe, the values that we are having now will significantly change by the time we wrap up the investigation.
I stopped listening at the second part of your testimony. You can go to page 288. Barrel 2.
I'm there.
I believe my learned friend started, if I'm not mistaken, in July, page 304. Are you there? It's 304. My apologies.
Come there.
You may proceed.
On the 1st of July, there's a payment, cash payment at Grove, $20,000. Do you see that?
I see that.
Prosecutor says that is a bribe. Where did that bribe come from?
Repeat that again, Mr. Isaacs. Which
Pros-
one are you referring to?
1st July 2022. I hope I'm good. If Melissa can just give me a direction, because I thought he started there. May I just quickly approach my client, Mr. Basson? I don't want to put evidence that is not put to the witness.
You may?
May I, Your Worship?
Yes, you may.
Thank you. May I just ask maybe a short adjournment of 10 minutes? I want to make sure that what I put to the witness is actually what my learned friend put to Mr. Willemse. Maybe also then use that as a bathroom break.
You may then adjourn for 10 minutes. You may proceed.
Thank you, Your Worship. We're just waiting for the witness.
You may proceed.
Thank you, Worship. Mr. Inambao, can you please go to page 304?
I'm there.
The allegation by the state, and it was put to Mr. Willemse, that 1 July 2022, there was a cash payment at the ATM of 20,000. You see that? On the credit line, credit column.
I'm seeing two credit transactions of 20,000. One is, that all of them they are for the 1st of July.
Can we deal with the very first one by
very first one.
logic deduction? All right. So that payment, is there evidence?
Mr. Isaacs, which page are you on?
Page 304, Your Worship.
304.
The first 20,000. Time 9:46.
On the 1st of July, 2022.
That is correct, Your Worship. May I proceed, Your Worship?
I see here, I see Deposit Grove window.
That is correct. That's the one.
All right, you may proceed.
Is that a bribe?
Your Worship, there are several cash deposits. At this point in time, as far as the charges that that Mr. Willemse is facing, we were able to quantify in respect of those charges, at least to how much we could connect before the finalization of the comprehensive financial analysis. We know that there was a lot of cash deposits, but at this point, Your Worship, I cannot say it's bribe or not.
Okay. I believe your same answer will be in respect of the 19,800 that just followed.
It's a cash deposit. It's an ATM cash deposit.
Yes.
And it just shows that, Your Worship, what it shows to me is, these are multiple transactions which are being made on the same day, which, could culminate, or at least is red flag. They could have been deposited through regular banking systems.
Mr. Inambao, which law of the Bank of Namibia or any law in this universe makes it illegal to deposit cash at the ATM?
No, it's not illegal.
Being a red flag doesn't make you guilty of corruption, sir.
I don't believe there's a charge relating to these specific amounts at this point in time, Your Worship.
I agree with you, Mr. Inambao, but my learned friend took his time to take each and every deposit up to 2023 and make the allegation.
And hence you are revenging it on me, or?
Sorry? Sorry, Mr. Inambao.
So hence you are revenging the questions on me.
Yeah, I must ask someone. I can't ask the prosecutor. Unfortunately, you are now the one in the door.
Of course, of course.
So what I get from you is that there are multiple deposits that we can see, cash deposits.
That's correct.
And it's being red flagged by you.
That's correct.
Thank you. Mr. Inambao, you see that we almost made a connection there.
Before you get sentimental, can we move on?
So sorry, Worship. So let's deal with the charges. I heard your testimony say that all the accused in this case face serious offences, and that is one of the objections against bail.
That's correct, Your Worship.
You agree with me that if you contravene Section 34B of the Anti-Corruption Act, that is corruptly giving gratification, that's a serious offense.
It is.
And that's an objection against bail on that, for that reason.
That's correct. And Your Worship, just to clarify, it's not a single charge that we are looking at. I believe there are multiple charges, and when they are taken holistically, they aggravate everything.
Yes, but Mr. Inambao, every charge on its own is serious.
Definitely.
Do you agree? Yes.
I'm happy we agree on that one.
One, two, three, 4, 5. What I find interesting is that what I just put to you now in terms of that contravention is that it relates actually to a charge of Connie van Wyk.
No, you didn't specify. You asked me the seriousness of the charge.
Yes, and that is one of the charges you face. Count 79, say contravening Section 34B of the Anti-Corruption Act. He's charged with that.
And hence I was saying, when we look at the charge, we must not look at a single charge. We must look at it in consideration of all the other charges that the accused person is facing. And I'm happy I was able to put that on record even before you informed me it's Connie van Wyk's charge.
I see. Did you also inform the court before Van Wyk was released on bail on 1, 2, 3, 4, 5 charges? Were you also happy when he got bail?
Your Worship, I did not testify. I did not place evidence regarding the charges of Mr. Van Wyk here. I was called here to come and provide evidence in the case of Mr. Willems.
I agree, Mr. Inambao, but you said to the court, let me introduce the court to Connie van Wyk. I didn't bring in Connie van Wyk, you did.
In terms of the deposits that he has made.
And because of the deposits, he's charged. I'm just building on what you told the court, how you introduced Connie. Now you say, because he's now on bail, I didn't testify about Connie. But those 1.2 million deposits relate to these charges.
You are totally wrong. They don't relate to those charges.
Oh, I see. To which charges does it relate?
As I indicated, Your Worship, Mr. Connie van Wyk was charged for other conducts in the same matter.
Okay. So Connie van Wyk is not charged after making red flag deposits into Mr. Willems' account, but Mr. Willems is charged.
Your Worship,
that's how I have your story.
Not necessarily. Your Worship, the charges, I believe, until at this point, investigations is still ongoing. Meaning, even as we sit, our investigators are busy working. So we are uncovering new pieces of evidence. For example, this new piece of evidence of the cash deposits that was done, it's something that we discovered after Connie had been released. So investigations is ongoing, and we find pieces of evidence every day.
Mr. Inambao, that is a lie. Let me tell you this. You only uncover it after he was released. You had this bank account of Mr. Willems in your investigation, correct? Is that correct?
But you should not say it's a lie, because I didn't use the bank statement. Hence, I'm saying preliminary financial analysis. Currently, we are busy with comprehensive financial analysis. So as we are performing the comprehensive financial analysis, we are picking up, so there's this transaction. We follow up on it.
But Mr. Inambao, you had this. When did you get the bank statements of Mr. Willems?
It doesn't matter when we got the bank statement. It's not Mr. Willems' bank statement.
It does matter. Because Connie van Wyk appears on his bank statement.
Can we not talk over each? What is the, I'm now lost. Because
he's saying that they only discovered these deposits after Mr. Connie van Wyk was released on bail.
What is the answer,
Which is not true.
Mr. Inambao?
Your Worship, the defense is lying because the charges of Mr. Connie van Wyk don't relate to that amount. And therefore, my version is the correct one.
That's the answer. Okay. Let's go to the charges of Mr. Willemse. You agree with me that before a person is charged, there's an investigation, correct?
Investigations is a process of gathering evidence, provided there is sufficient evidence proving that an offense was committed. A person can be arrested. And once a person is arrested, the charging is part of the process, which is what we have done with Mr. Willemse.
So you agree with me that there's investigation, if there's evidence, person will be charged, correct? Arrested and charged, correct?
That's correct.
I don't know if you have a copy, but I can go through his charges painstakingly. My learned friend dealt with 2 charges with you. I think count 8 and the conspiracy charge. Count 8 says that Mr. Willemse received a directly $3,010,000 from NAMCOR and Irongo Petroleum for authorizing supply of fuel above the credit limit. That is the charge. You told this court, Mr. Willemse is not charged for increasing the credit limit of NAMCOR. Yet, our first charge relates to that. What do you say about that?
Your Worship, point of correction again. We are not talking about the credit limit. And I want the court to understand that the credit limit is something that we have packed away as far as our investigations is concerned. We are talking about authorizing the supply of fuel above the credit limit.
Yes, we do.
If the name of Irongo is mentioned in the charge, Your Worship, as it stands here, as the counsel was reading, these are preliminary charges, Your Worship. But there is evidence that he received the money directly in his personal account, Your Worship.
Mr. Inambaum, you must listen to my question. When I wanted to discuss the issue of Mr. Willemse authorizing the fuel supply above the credit limit in respect of NAMCOR, you said he's not charged with it. I'm proving to you that that is not true. Because count 8 relates to a gratification for having authorized the supply of fuel above the credit limit for 2 entities. One is Irongo, one is NAMCOR. What do you say about that?
Your Worship, I've testified. We have provided records, rather evidence indicating which fuel, for which entity did Mr. Willemse approve. And hence I pointed it out to Mr. Isaac that maybe it's preliminary charges.
Yes. The problem with the preliminary charges, Mr. Inambao, is that the court must deal with these preliminary charges now because the bail application is now. And on the preliminary charges, the court must assess whether or not on the preliminary charges, whether the accused is a candidate for bail, i.e. the state is not a candidate for bail because the state has a strong case. So your excuse or justification of its preliminary charges, unfortunately, it doesn't help the court.
It's not an excuse, Your Worship. We have set our record straight here in terms of the evidence that we testified, Your Worship, that Mr. Willemse approved fuel in respect of Irongo Petroleum.
All right.
So, and in this charge, Your Worship, there are 2 listed entities. You just strike, it's what I was saying. As the state was compiling the charges, probably because there are 2 entities that people were looking at. So, Irongo is still in that charge.
Okay. How is the amount of $3,010,000 Namibian made up?
I believe the amount is more than that.
So the charge is wrong.
As I testified, I was able to put figures. I told you there's a 1.2 million that we know is cash deposits. There's a 500,000, there's a 550, there's a 350, there's a 150, there's a 50,000. If you put all those together, they can exceed that amount.
I see. The charge also says he received it directly.
It went in his account.
Not through QMS or NAMCOR. It says directly from NAMCOR and Irongo Petroleum. That's the charge. Do you agree with me that your evidence doesn't support this charge?
Our evidence, I believe, is fair evidence, and we have demonstrated that. If there's an omission of a word there, I'm sure that would be corrected. But we are saying he received money.
All right. He was also then charged with fraud, that is count 9, where it is indicated here, again, NAMCOR pops up, that NAMCOR suffered a loss of $3,010,000. Unfortunately, we do not have the bank statements of NAMCOR, but can you prove that? Does your evidence shows this? That NAMCOR suffered an actual loss of $3,010,000.
Your Worship, from my understanding of this charge, if you look at the amounts, it's similar with the one on top, or with count number 8. And I believe, Your Worship, it's fraud in a sense that Irongo and NAMCOR, as indicated in the charges here, they had debts with NAMCOR. Instead of paying NAMCOR to pay their debts to NAMCOR, they paid the staff members, including Mr. Velemse, money which they could have paid to NAMCOR.
Is that your answer?
That's my answer.
Okay. Charge number 9, that's theft by false pretense, or sorry, alternative to 9. Are you there?
Yes, I'm there.
Is the element of corruption, if you act corruptly, is it part of the elements of theft by false pretense? We've learned that you do both. You have experience in both.
Your Worship, when you look at this charge, it's an alternative charge to fraud. Because theft under false pretense, basically there's an element of misrepresentation. Although it is not, that is why you don't see that it's an alternative to a Chapter 4 offense.
Yeah, but the charge also says corruptly in a theft under false pretense charge.
Yes, but fraudulently also. That is why there's a theft under false pretense.
Yes.
It's because that money, that is the money which should have gone to at least, that 3 million could have reduced the debts of those entities.
Could have.
Had it been paid, there would be $3 million less in terms of how much it went.
Now, the 30,808,581.50. Whose credit limit was that?
Your Worship.
Which one was exceeded, sorry?
This is in respect of purchase order number 5. My apologies, Your Worship. 119. That is the amount, that is how much fuel was supplied to Irongo in respect of purchase order 119, which we know it was approved by Mr. Velemse also.
Okay. So not NAMCOR?
That's correct.
Okay.
Your Worship, Okay.
Yes?
No,
Yes,
it's-
yes. No. It's your time. You can speak.
No, you can proceed.
Oh, okay, thank you. Count 10. Fraud. We know for a fact that
Is count 10 fraud or the corruption one? Because I'm seeing there's a...
the one that deals with the fraud of 1,040,000. Are you there?
Here in the document I'm having is read section 35. Count number 10.
Is there a count that relates to 1,040,000?
Yes, it's that one, which is contravening of section 35.
Okay. You'd agree with me that that money was not paid directly by Enercon or Irongo. Directly. The operative word here is directly.
Your Worship, the choices of the grammar used in formulating charges is not mine. The evidence that we have gathered have proven that Parkwood Petroleum, as an entity of Mr. Willems, received that money.
So Parkwood was not a supply and logistic manager. Parkwood itself, the company, was not a supply and logistic manager, correct?
I am trying to process your question. Maybe you can
Take time, take your time.
rephrase it.
The charge says that the supply and logistic manager of NAMCOR is allowed to facilitate the acquisition of the assets. But the money is paid, the charge relates to the actual and loss of 1,040,000 that we know, and you testify that was not paid to Mr. Willems, but to a company called Parkwood, of which he was the sole member, correct?
Correct. I believe the supply and logistics manager there, it was the occupation or the title that Mr. Willems was occupying at NAMCOR.
Okay.
When this transaction was concluded.
But he's not charged in this charge, he's not charged as a member of the CC, but he was charged in his personal capacity as being a supply and logistic manager. Do you agree?
Of course.
Thank you. Then we have count 11. That's alternative to false pretense, theft under false pretenses. You say that this money was supposed to go to NAMCOR and not to Parkwood. That's why this charge is here.
Is it count 11 deals with fraud?
It's alternative to count 11.
You're looking at the alternative to count 11?
That's correct.
Okay.
The count 11, if I am correct, is the fraud, and then alternative is theft under false pretense. Are you there, Mr. Inambao?
I'm there. I'm just trying to read the
Oh,
charge.
sorry. Take your time, please.
Your Worship, this charge is very specific and clear.
Okay.
Mr. Willems was indeed, a manager supply and logistics. He was very much involved in the acquisition of the assets from NAMCOR. And we know that, by NAMCOR from Enercon, in terms of evidence, it indicated that his entity, which he holds 100% interest, received 1,040,000 from Eco Trading, Your Worship, direct proceeds of money that was paid by NAMCOR to Enercon.
Again, Mr. Willems is charged here in his personal capacity, correct?
That's correct.
And according to the charge, he must represent to NAMCOR that he was allowed to facilitate. That's the misrepresentation according to the charge. Do you agree?
Yes.
You did not dispute that the MD requests Mr. Willems to participate in that acquisition process. So how did he misrepresent that he's allowed?
Your Worship, an unlawful instruction can be refused even if it comes from the managing director.
Okay.
So what we are looking at here is the criminal conduct that happened, the participation in this regards. We see money going to his account.
Yes. Mr. Inambao, you make statements and then you just go away. So let me just deal with the first statement that you made, that sometimes instructions can be unlawful and then you can refuse. Is it your evidence that by the MD asking Mr. Willemse to assist, was that an unlawful instruction?
That is not my evidence. You said I didn't dispute the fact that he was instructed by the MD.
Yes.
And hence I'm saying an unlawful instruction can be rejected even if it's coming from the MD. That was his prerogative. But what we are saying is he participated in this. And in terms of the criminal conduct which we see, after the assets were acquired, money went to him.
So Mr. Inambao, what was the relevance of you telling the court an unlawful instruction can be refused?
I needed to address part of your question.
Okay. Count 12. Count 12 you say relates to the purchase order, one of the purchase orders, correct?
Yes, in terms of the amounts listed there, it also relates to purchase order 119.
Yes, and that gratification was for Irongo Petroleum, correct?
That's correct.
All right. Count 13. I see there's no other amount like the 2 million that he also unauthorized, and 28 million. It seems to me that you the charges zoom in on the 30 million, correct?
And hence, Your Worship, I was saying investigations were still ongoing, and maybe these were preliminary charges, because as far as the evidence is concerned, those purchase orders we presented, they were approved by him. And hence, I was saying earlier that by the time we are done with a full financial analysis, these amounts, they will change.
But Mr. Inambao, you had all three of them during your investigation, before the charges. You had all three purchase orders.
In terms of the evidence, yes. In terms of compiling the charges, we know whose responsibility that is, and the time constraints that was there at the time.
Do you suggest that once the investigation is complete, we must come back for the actual bail application? Or we should disregard these charges now because they are preliminary. We must, once the charges is somehow final, then we come back for the bail application. Is that what you say?
We are here for the bail application, and all I'm pointing out is this figure here. It's actually less than the actual figures at the end of the day.
Yes. Count 13 relates to dealing, using, holding, receiving, or concealing gratification in relation to any offence. Are you there, Mr. Inambao? Relating to the 4,050,000.
I believe this is the money which went into Parkwood. When you remember, there was a transaction of 3 million on some of the charges there. I just can't remember what was
310.
that. Yes. So if you add that one together with the 1,040,000, it makes up the amount in count 13. This is in respect of the money that he had received through his banking accounts and business account, which were proceeds of crimes.
Yes. And you say that he received these amounts from Enercon and Irongo, correct?
That's correct.
All right? And you will see the 1,040,000 is included in this amount, but in this case, again, he is charged in his personal capacity. Correct?
That's correct, because if you look at the other 3 million, is money which went into his personal account.
Okay? Then you say your absolute favorite charge. This is the last charge I'll be dealing with. Maybe you can just take a lunch break, and then I'll deal with the grounds, and then I should be. Sorry, in fact, there's 3 more. Then I'll deal with the grounds, and then that will be cross-examination. Hopefully, we can finalize cross-examination before end of business today.
Okay, we will then adjourn to proceed at 2:15.
As a court, please.